Good morning. This webinar offers closed captioning. Welcome to the City of Chicago Department of Business Affairs and Consumer Protection's free business education webinar. This webinar is being recorded and will be available at youtube.com/ChicagoBACP. There will be a Q&A session during and at the end of the presentation. All BACP webinars are part of the BACP Entrepreneur Certificate Program, which is a free program for anyone interested in starting or growing a business in Chicago. Getting your certificate is as easy as 1, 2, 3. 1, register for the program. 2, attend 6 webinars in 6 months. 3, graduate and get your certificate. Graduating makes you eligible to apply for CIBC Bank's Entrepreneurial Loan Program. Note that you must already be registered for the program to get credit for attending today's webinar. For full details, visit chicago.gov/BACP certificate. Views, information, and opinions expressed during this webinar are those of the presenter and are not the official policy or position of the City of Chicago or BACP. The information mentioned will be posted in the chat box. Today's webinar is How to Identify and Protect Your Intellectual Property, presented by the National Association of Women Owners, NAWBO member, Michele Katz. Turning it over.
Good morning, everyone. And just to set the scene, it is a hot, sunny day in Chicago, perfect for the Air and Water Show, where I will be heading this afternoon. And we'll see if any of the practice runs, we'll be hearing them during this next hour and a half or so. So again, my name is Michele Katz. I am a past president of NAWBO, the National Association of Women Business Owners, back in 2015 and still involved. The mission of the organization is to propel women business owners into political, economic, and social spheres of influence. And we are the premier organization to do such that across the United States. I am an IP lawyer, and we're going to talk all about intellectual property today. Intellectual property includes a whole host of different areas. It's basically the umbrella. And so we're going to get into the why, the what, the how, all of that. So I understand that online today we have new business owners and veteran business owners and everything in between. So I'm hoping my goal for you today is that you learn something, you take something out of today and you apply it directly to your business. Okay. So my firm is Advítam IP, which stands in Latin for intellectual property for life. I've been practicing in this area for 25 years. Okay. So as you can see right here, Advítam IP LLC, right here at the top left of the screen. And a lot of times people think that's the trademark, but it's not. And so when we get through the slides, you'll be able to distinguish, I hope, between a trademark and a business name and a copyright and a patent and a trade secret, okay? And everything that we can possibly get out of today, let's do it, okay? Here we go. Why is it important, intellectual property? And I named a few types here. There are others, but these are the main, I would say these are the main 4. Patents, trademarks, copyrights, trade secrets. They are all different. They each have their own system. Fees. Trade secrets have no fee, sort of, not with the government anyway. And we'll get into all of those details. And then IP best practices. All right, so that is for your own business. Can you identify your intellectual property? If so, then what do you do once you identify it? How do you enforce it? How do you keep people out of your market share? Right. So we're going to cover all of those things. First, a definition. Intellectual property. It refers to the creations of the mind, such as inventions, literary works, artistic works, designs, symbols, names, and images. Okay. So when we talk about creations of the mind, think to yourself, does that mean my idea is intellectual property? And would you say to yourself, yes or no? And I would say, and intellectual property lawyers would say, it's not that you can protect the idea, but the expression of that idea. Okay. So that expression includes the inventions, the literary works, the artistic works, designs, etc. Okay. So keep that in your mind that your idea is not protectable. It's the expression of that idea. Okay. So why is intellectual property important? Okay. And I have a list of reasons. I'm sure there are more, but these are ones to keep in mind as the prominent reasons why we care about intellectual property. Okay. Now, if you're selling products or services, you want to make sure that you are known as a single source for that product or service, right? You don't want someone to think it's you, but actually hire someone else. Naturally, they're not going to do as good a job, and then they throw up a Yelp review, right? So it's a negative one. And those are very hard to get down, right? So intellectual property is important to literally carve out your market share and have the ability to keep others out of it. Okay. And we're going to talk about these 4 types today. All right, we're going to start with patents. Okay. That's typically inventions. And the government grants the right to exclude. That means it's kind of like when you think of a monopoly, right? So if you come up with an invention, you file for a patent, it lasts 20 years. You don't get forever, lasts 20 years from the filing date. And so what kind of items or inventions, what kind of creative work falls under the patent category? And then I have some listed here. And if there are any here that surprise you, feel free to throw it in the chat. We can have a conversation about it. Right? So, did you come up with a new process or a machine that does something better, faster, cheaper? Right? Same with manufacturing. Can you do it better, faster, cheaper? Then you might be eligible for a patent. Okay? And then actually literally creating like a new plant variety. Or here, like a new chemical compound, right? And then you see improvements, right? So when we talk about patents, so say you get the certificate, and keep in mind, it takes a while to get. The ability is for you then to send a cease and desist letter to someone and attach your patent and say, hey, this is mine. Stay out of my way. Stay out of my sales, essentially. All right. And that's the right to exclude others. You can stop them from making, using, or selling the invention. But it takes a while. So, 18 months, especially since COVID, a lot more people are filing trademarks and patents. There's definitely been an uptick in waiting time. Yeah, it really could take 5 years. So we do say file early, file often. And for some of our clients, we have basically, we promote now, because the wait time is so long, is to file something called a provisional application. I don't know if anyone online has heard of that. It's like this abbreviated application. You can, it can be from just the drawings, very minimal, and it can be to almost a full application. And a full application is called a non-provisional. Okay. What the provisional allows you to do, which is really pretty incredible, is to be able to go, you get to say patent pending. So that's great. If you happen to be pitching to, for more capital, you can, to say that you have something patent pending is pretty strong. They may be more likely to even have a conversation with you. There are definitely companies that won't have a conversation with you unless you have some sort of proof that you are invested in your intellectual property. Okay, and then duration we talked about. All right. So does anyone have any questions on patents? Just as general questions about patents before we move on to trademarks? And throw it into the chat.
One question did come up. Are patents only for physical products?
So no, not necessarily. There's something called a business method patent. I don't know if anyone's heard of that business method. So it's the way in which you do business. There is case law that makes it extremely difficult to enforce, but it can be done. And product doesn't have to be the product itself. It could be how you manufacture the product or products. I hope that helps. Any other questions about patents? Feel free to drop it below. And just because we're moving on to trademarks doesn't mean we can't talk about patents later. And think about also, there's more than one way to protect. Say you have a physical product, say you have a patent on it. Fabulous. What are you calling it? And we're going to get, not to spoil it, but I think a lot of people have some familiarity with trademarks because it's what we see, in the stores. It's what, online we see. We're inundated with trademarks, right? All day long on our phones, right? So what are you going to call your product? You got to call it something, right? So let's chat about trademarks. Trademarks, and there's some examples down below at the bottom of the slide, right? A lot of times people just call them like, what's the branding, right? That's just another way to say trademark, okay? It is a way to actually identify the source of the goods. Okay, so we have some examples down below. You've got words. Look at the Cabbage Patch one. That's an old favorite for some of us, right? Who grew up with Cabbage Patch Kids, which were all the rage. So you've got the actual words. You can see the words in Coca-Cola. You can see the words in the Starbucks coffee. Or you don't have to have a design at all, right? You can just have the words, right? Like Nike, right? It can be just the word Nike, right? That is a source identifier. And that's what we're thinking of when we're thinking of trademarks. It's identifying you, okay? You're the source of the goods and or services. You don't even need words. If you see the Nike swish on something, you're going to assume, oh, okay, it's a Nike product. If it's not, and your Nike shoes or your Nike joggers or whatever fall apart, you might really wonder, like, can they stand by their quality? If that's the opinion, if you have a positive opinion about Nike wear, right? So if it's just the symbol is very powerful. Like if you saw, for example, a Starbucks coffee and you didn't see the words, but you actually saw like the green circle on the outside and then, the Starbucks goddess in the center, right? You would know. You don't even need the words. Or, right, in the center here, do you you recognize these rings, right? These 5 colorful rings without it saying Olympics. You recognize it. And it can actually be shapes, believe it or not. Shapes can be a trademark. Think of the old that Coca-Cola bottle. They have a trademark on that. So 3-dimensional objects, I'm not saying it's easy to get those. It takes time. There are certain rules of a minimum use, exclusive and substantial use for minimum 5 years. It makes it much easier to then obtain a shape for the form. Okay. So don't worry, we're going to do a deeper dive into trademarks. So just like patents had rights to exclude, same with trademarks. Okay, you file for your trademark application. Doesn't take as long. Still takes longer since COVID. You're not really seeing too many with a year anymore. Now it's more like a year and a half. And the trademark website actually finally caught up with its own timing. Because it used to say 3 to 4, it'll take 3 to 4 months from filing to get assigned to an examiner. Okay, because there's actual human being that gets assigned to your application when you file it electronically, and everything's filed electronically these days, and has been now for a long time, for patents and trademarks anyway. And now finally it actually tells the truth, because it's more like 6 months, could be even longer, just to get assigned to an examiner. Huge uptick. I think people were at home, people were creating, bored, right? Breeds creativity, right? But still, probably I would say a year and a half would be the minimum, but it could definitely take 3 years, especially if you're not using the mark. So just like patents had that provisional application, which was like the abbreviated patent application, and then you have the full breadth application called the non-provisional. Okay. With trademarks, you don't actually have to be using the mark yet. What if you want to kind of capture it? You want to capture the mark, you want to file for it, and it's called an intent to use application. It means you're intending, you have a bona fide intent to use the trademark, but you're not going to be using it yet. And because you can file extensions before you have to prove use, and eventually you do, if you're not a US applicant, you have to prove use before it registers, you can file extensions of time. So I tell clients, I say, okay, you're using this now. Are you planning on broadening your scope of products within the next 3 years? And are you okay with potentially paying, there is a government fee and a lawyer fee for filing extensions? The benefit of capturing it now instead of waiting till later is someone could have come in, filed for your broader goods or services. Okay. The really neat thing and unique thing about trademarks is they can last forever. I mean, of course, there's a catch, but if you are using your mark and you continue to use the mark, you can keep renewing every 10 years. Assuming your mark registers, okay, your application registers, then what happens is between the 5th and 6th year after it registers, you have to prove that you're still using. I don't know why it's between the 5th and 6th year, but between that anniversary, what happens is you have to prove that you're still using it, which is actually submitting a specimen of use in commerce. Okay. And then at the 10-year mark, just a few years later, handful of years later, and then it's every 10 years after that. Hey, and if you're using it and you can keep proving you're using it, it lives. It lives. Okay. Let's pause for a moment, and I'm going to ask any questions about trademarks.
I don't see any about trademarks, but we did have some more come in about patents.
Oh,
so-
well, okay, I'm fine with handling them now.
Okay,
Can you tell me what they are? I'm not seeing them
sure,
pull
no
up.
problem. What does a patent process look like?
Okay, so first of all, before you file for a patent, you want to do a search. Okay. Law firms typically use a third party company, or they can do an internal search. And what they're searching is for literature and pending or issued patents that relate to the technology. Okay. But specifically to what is it that you've innovated? What's new, novel, and non-obvious? Those are the elements to actually obtaining a patent. So what happens in the patent world is we don't necessarily know everything just from searching online, because you could actually file a patent, your patent issues, and never practice the patent. You never create it, right? That inventor can still block you. So first thing is, let's see the world before the patent and trademark, it's the patent and trademark office, but the patent side. Okay. Also, we can do literature searches. What are people talking about out there in the world? Okay. The journals that relate to your particular field. Okay. And you certainly don't want to talk about yours yet because there's some absolute bars, or they start clocks. Um, so what I mean by that is if you start talking about, say you're at a trade show and you're going to be talking about the new greatest thing, you may have started a clock, a 1 year clock, where if you don't file your patent application before that 1 year deadline, it's now belongs to the public. That can be a real shocker for people. Okay, so if you are talking about your invention, if you've heard of an NDA, non-disclosure agreement, you'll want to have your lawyer draft something up that makes sense, or you can do it yourself. But it would be a good idea to have, a family member lawyer look at it, or an IP specific lawyer look at that, because there are certain things we are including in those type of agreements. Okay, so we haven't even gotten to filing yet, which is the question. Okay. There's also something called an absolute bar. Well, it's another time is ticking bar called the on sale bar. So if you haven't filed your patent application yet and you are offering it for sale, that's problematic. Again, that's another 1 year clock. And if you're planning on selling and protecting your invention in Europe, say, there are absolute bar countries where you can't even talk about it. You have to get that patent on file first. So bottom line is, when it comes to those sort of things, definitely consult an IP attorney. We do these kind of conversations all the time, and it is not unusual for people. It's not general knowledge, I feel like, that people know that. Okay, say we've done all that though. We've done the search, we've reviewed it, we've discussed it. We're like, okay, we now know we might have to narrow what we were originally going to claim in our patent claims because of what else is out there. Because you don't want to just waste money, file it, look how long it takes just to get assigned to an examiner, which in the patent world can take even longer than the trademark world. And then you're blocked, right? That's one of the huge benefits of doing a search in the first place. Okay, so once you do that search, you're comfortable, okay, then you with the lawyer, or the lawyer can draft with your help. You got to be involved in the process. If you're not involved in the process, then you may not be claiming exactly then in the end, if you're enforcing against someone else, how the invention is actually practiced. It doesn't align with the patent is a very big problem. Okay, so you want to be involved in that process. You want to review, you want to make sure the patent lawyer will, of course, make sure, or patent agent. And the difference is patent lawyers go to law school, patent agents, they don't typically. They don't. Patent agent means they are drafting patents. They're not before the court, whereas patent attorneys can be before the court. So all that is to say is, once you have filed the application, it gets assigned to an examiner. Okay, you wait a while, quite a while. Then the examiner reviews it, will review the technology. The patent office is divided into arts. Okay, so there'll be different art divisions, and your patent will go to the particular appropriate art division. It'll get reviewed by someone with a tech background in that area. And then you'll be having back and forth communications. You can have interviews with them, meaning by phone. Normally, what they do is they issue something called an office action. Okay, they will tell you, we don't like this wording, change the wording like this, or they'll say, we found something that blocks you, prior art. Okay, and we are responsible for providing prior art, but it does happen. You miss a prior art, and then we've got to figure out, okay, now how do we continue to narrow, still obtain our patent, our issued patent? And sometimes that does happen. But that's why the search beforehand is so important, because it helps you. We don't have crystal balls. We don't necessarily know for sure. It can't be guaranteed 100%, but we try to find as many obstacles beforehand as possible, and then draft the application to avoid them and reduce complications so that you can get that patent out, that patent issued. And then there are maintenance fees. So just like I mentioned with trademark renewals, how they last in perpetuity as long as you're using it. With patents, that's not the case, but there are still maintenance fees. Government still wants their money. Okay. And we have a docket system for that. So what happens is as we docket, there's a window of time. Windows open, we let you know. You can of course docket on your end as well, which we recommend, right? And then you pay those fees. And there's no proofs. It's literally just fees. Does that help? Any more questions on patents or trademarks?
Yes, there are a few.
Okay.
You kind of touched on this, but this is specific. What is a time frame of protection on a non-provisional patent?
Right. So that's on a non-provisional, that's the full patent. So that's the 20 years from the date of filing.
Great. Can you patent a program model?
Might be. Yes. Programs can be. But we're going to talk about copyrights. And then the person who asked that question, I want that, depending on the kind of model they're talking about, copyright might be an avenue. And there are pros and cons to all of these areas. And that's another reason why it's important to have this understanding. I always say, we teach a lot with my firm, Advítam IP. We definitely believe in educating our clients so that they can make better business decisions when it comes to intellectual property, which to us is the center. It is the core of the business, and everything else is on the outside. Okay. Which is not always the case. I feel like in many cases that the trademark is kind of like, or the patent, it's on the outside, and maybe the core is something else.
Okay, great.
So let's get into copyrights, and then let's hold that question because I
Sure.
want to hear back from that person and see, like, maybe we can have even a discussion about it if we have time and that makes sense. Because copyright, a lot of things that are let's get into it. Was there any other questions?
Is it possible you have to do it every 5 years?
That's probably for trademark then. So on the
Okay,
trademark side, it's not every 5 years. If we're talking about trademarks.
most likely.
Okay. So yeah, is it possible? Okay. Okay. Yeah. So 5 years. Well, I guess if it's a program model, that could be related to the above question. But I'm not sure. Okay, I could do both. We'll do both. Okay, so if it's trademarks, then no. Anytime you change your trademark, you should file an application, because when it comes down to time to renew, you could have a problem, right? Because what the mark you're actually using doesn't align with what's actually covered by your trademark registration. So you got to always be mindful. That's definitely the use and registration, they go together, right? As you change your use, you need to file a new application. You can't amend, you can't amend to change to the new, when companies are doing rebrands or like more like a refresh. Okay. It's one thing if you're not changing the words and you filed a word mark, you're fine. But if you filed a trademark application and you have a registration on some design, but you change the design or you change the words or whatnot, you got to refile. Because it's not every 5 years. There's that first, after it registers, that's between the 5th and 6th anniversary of your registration, you have to prove a continued use. You got to do that, or it'll be canceled. It'll expire. Then what happens is at the 10-year mark, so basically 4 to 5 years later, you got to do the renewal. Okay. Renewal, you have to still prove we still have to include specimens that you're using the mark. Okay. In commerce. So then you've got that 10-year, 20-year, 30-year, 40-year, and so on. Okay. That's for the trademark side. If we're talking about patents or copyright, if that question is relating to that, when you make changes, so similar to trademarks, right? When you make changes, you should consult your IP attorney to potentially file, and it could be a continuation in part. There's different kinds of patents, especially if your patent is still pending. So that's a little bit more complicated of a conversation for today, but it is interesting that if you are making changes, like think about software. I mean, 5 years, your program is like obsolete potentially, right? So, and if you've kind of kept up, you need to keep filing. You need to keep filing. But software to me is not so much patent. Is not so much patent. You'll see why when we get into copyright. Okay. Let's see. Oh, and okay. So right. So if I develop a computer software or application, do I need a copyright or patent? Well, it kind of depends who you ask. What's your budget? Those are legit questions to ask because there are times when maybe both. But I would say copyright, and you'll see very soon, copyright is more typical for software, for like code. Okay. Same for websites. Okay. Oh, and there's a trademark question here too that I see.
Yes.
Can you explain what exactly can be trademarked using Starbucks as the example you mentioned, the logo colors? Yeah, you can protect just on colors. Like do you ever go to Home Depot and everything's orange? Yeah, you can protect colors. Even my firm, so I'm sitting at my downtown office today and I have 4 registered trademarks. My firm. I mean, I'm a co-founder of my firm. So I've got the word mark, Advítam IP. Okay. I've got my tagline, identify, protect for life, also registered, just the words, just the words. Then I have my symbol, like my logo, which is it's just imagine like the Nike swoosh, right? But it doesn't look like that, of course. It's just in black and white, no claim to color, because I'm looking on the wall and I see it's the accent mark in Advítam. It's the accent mark, and inside it, there's a little I and a capital P. Okay. And then the 4th one, color. Orange. Orange is our color. So we have that same, what was in black and white is in orange, and we claim that color and we were able to get it. You can also trademark scents. Scents. Yes. Perfumes. Yes. You can trademark that. You can trademark sounds. Does that ring a bell? NBC. Right? You can also trademark sounds. There's a lot you can do, actually. But then there's, of course, things you cannot. Okay. It's got to be considered, can't be generic. Companies that have lost their trademarks. Can anyone think of any? If you want, throw it in the chat. If you can think of trademarks that have been lost. Anyone? There's a great video that I've seen about genericized marks. Did anyone think to themselves, I don't know about Kenmore. I don't know. I don't think so. But I mean, really become a household product, right? So it doesn't even matter if it's the real deal or not. That's you've lost it, right? So elevator. Elevator was a trademark. Linoleum. Right. So you think Band-Aid, but they came back. Same with Kleenex. Some companies came back. Yeah, someone wrote it while I was saying it. Those brand, now you see Band-Aid brand adhesive whatevers. Okay? Yeah. So some company, Xerox. Did anyone think of that one? Xerox. But companies then said, no, we can't be that, they've actually fought back. And you've seen, if you recall, there was certain, or if you're kind of aware of it, I would be, of course, be naturally aware of it since it's what I do for a living. But yes, there are brands that have failed right? Didn't realize, yeah, maybe thought it was a great thing. And then there's those companies that have fought back and said, no, we're not going generic. We're not generic. We are Kleenex brand tissues. We are Xerox brand copies, photocopies, right? Yeah. So, okay. So we've got that. Let me see. Am I missing anything else? Oh, how often are the patent fees paid? So there's different windows of time. So 3, 5, even up 12. I mean, there's different times. And we haven't talked about design patents. That might be something to consider also for certain people. This, we would talk about it. They don't last as long. They're 12 years. But they that's also kind of an interesting avenue for clients to consider a design patent. Some people really want the patent, and so we would obviously have that discussion, which is the best way to protect it, and for that aligns with your business needs.
There
Uh,
is one question. What can a business do in the meantime for trademarks? Do we just use the TM?
Okay, really good. That's a really good question. So, with the yes or SM, has anyone heard of or seen SM? It means service mark. Service mark. Yeah. So what that means, TM or SM, it means that either you have a trademark application pending, or you have no application pending and you're just using it. We call it common law use, where you're just using it without federal protection, or maybe you have a state registration. Believe it or not, all 50 states have their own trademark system, like filing system. Federal, of course, overall it would be cheaper. It makes more sense if you're online, or of course, if your goods are crossing borders, which is often the case, but not always. Maybe you've got like one solo restaurant, and maybe getting the state maybe that's enough. Just getting the state registration. So it's worth a conversation with someone who knows this stuff, so that you can make the best decision. You don't want to overspend. I hear the airplanes now. You don't want to overspend on something that you won't use. But if you're trying to get someone, like if you do have, your goods and services are kind of crossing borders, then federal is the way to go. And then wait, did I answer that fully? Using. Oh, there was what designates still using in trademarks, one sale or use or many. Well, some people might say de minimis, meaning muy poco, is not good. I would say more is better. One, not that would be tough. That would be tough because you get the de minimis argument thrown in your face. So I would say definitely I would say more than one. But here's the thing. It's not necessarily that you sold it. It's actually that the offer for sale. I mean, they're not going to, so say you only sold one, but you offered it for sale. And if orders were made and you could fill them, then you're fine. Should be fine, right? Lawyer response. But should be fine, because the idea is, like, you're not penalized necessarily for like success or lack of success, certainly in the beginning. But if you're offering it, say you're offering it online, that's like to the community, your local community plus, right? And you can fulfill orders, then that's a different conversation. Okay. And that's good. Let's see. How much is copyright? Copyright is interesting. If you're an individual, they charge you less. If you're a business, they charge you more. But it's actually not, it's more expensive. Patent and trademark fees are more expensive than copyright fees. I think they definitely have gone up. For the individual, I don't remember offhand. It used to be like 25, really, like very inexpensive. And then corporate, if you're a corporation, you are 55. That went up to 65. And I think the individual went up to 35. But we always check online for the fees to make sure we're current, because they just continue to increase them. They were put for a long time. They were the same. And the last I saw was 65 and I think 35. That's on the copyright. And then there may be an attorney fee if you're having an attorney help you. And we charge flat fees for that kind of stuff. Okay, then we're going to talk about webinars, training modules in copyright. So we're about to hit that. And can someone use an image that is close to your trademark and get away with it? So it depends on how close. Yeah, it depends on how close, because the rule is the same or similar mark in connection with the same or similar goods or services. That's the rule. So if someone's being shady, okay, and they've like maybe flipped one letter, but other than that, it looks the same and people are being confused, it doesn't have to be identical for the infringement conversation or analysis. It does not have to be exact. Okay. Okay, great. Great. And what do you think are the risks of choosing a similar name that is too similar to an existing one? I wouldn't recommend it. So just like we were talking about in patents, and we want to get the scope and make sure that that what we're drafting gives us the best chances of success. Same with trademarks. Okay. So we do searches also for trademarks. We do heavy searching on trademarks, not just typically what we care about, what is pending and registered before the United States Patent and Trademark Office. Now we're on the trademark side. We do care. And we also care on what's online, because someone could have common law rights. Say they haven't filed. They haven't filed, but they have common law rights. You get your federal registration, but their use is actually earlier than yours, and you might not be able to stop them because they have earlier use. It's called a Swiss cheese registration. So it is important that you maximize your rights. And you do that not just once you get it, right? Not once you get the registration, assuming you get it. It actually starts earlier, right? With a good search. Okay, so if I trademark the main company and have a photo service as one of the services with its own name, do I trademark the photo service too and copyright the photos as well? So this is where we're going to layer. Okay, let's go back to that question, because I want to get through some trademarks, and then you'll kind of see how we layer. So you could have, and you can have more than one trademark. So the main mark, okay, and keep in mind that your company name is not a trademark. Okay, we're going to talk about that. It's one of the most confused, I think, when I'm talking to people, that they don't realize that when they form their entity with the Illinois Secretary of State, for example, that they don't have a trademark, and the Secretary of State is not connected in any way to the United States Patent and Trademark Office. Okay, we got to cut that. It's two separate bodies, both important in their own way. Okay, so let's talk about copyrights. So original works of authorship and fixed medium. It has to be in a fixed medium. Okay, so there's some examples below. And again, if you look at the definition, we're talking about expression, right? Remember in the very beginning, I was talking about it's not your idea, it's the expression of that idea. And the expression can be in the form of an invention, i.e. patent, a brand, i.e. trademark, or in a book, a screenplay, sound recordings, etc. And you can see them listed there. Even architectural plans. And I mean, we've been talking, it keeps coming up, computer software. Really, computer software, copyright is a great way to go. Okay. Now this is unlike, okay, on the right side, yes, it's similar to patents and trademarks. Okay. It's the right to make copies and authorize others to make copies. Okay. So that's with all the things, right? It gives you the right, and only the people you say it's okay can also have the right. Okay. But that's up to you. And it should be in the form of like a licensing agreement, not just a handshake and whatnot. Better to have things in writing, even if it's just like an email. My understanding is this, blah, blah, blah. Yeah, you agree. Okay, great. That's an inexpensive way to do it. Of course, we like to have it a little bit more formalized. Okay. And to make derivative works, right? So if you own, okay, we can talk about Disney. It's complicated, but let's talk about Disney. If you make a painting of, let's say, Mickey Mouse, okay, let's go back in time before the whole public domain thing occurred, but then you still have to get the rights from Disney to make a derivative. They own the derivatives. Okay. So, okay, let's take a better, okay, a very accurate example for today. You write a book. Someone takes your book and translates it into Spanish, French, German, whatever. Okay. You actually own the derivative. That's a derivative. It's not your exact work. Someone translated it. That's still your work. That's a derivative. Okay. You sell you've got the right to sell the work, display. Maybe you're an artist, sculptures, all of that. Okay. Maybe it's recipes. Recipes can also be covered by copyright. Okay. Or perform the work in a public forum. Right. So you've got, like, say you go for like you go watch a cover band. Is that legit? Are they actually able to do that? Not necessarily, right? Did they get permission to do it? And you see, like, there's all these companies now that are contracted with celebrities, artists, performers. And so if you're playing music, are you paying the license for the music? There's several companies now that, of course, kind of patrolling venues, like, it could be, locally here, I would imagine, like, say the House of Blues or whatever, or if, like, your DJ, right? The DJ probably has to have signed on and can only play the works for the artists that sign on to that company, right? And there's several companies. So that is something, because of their copyright. That's why. So the timing, it takes basically 8 to 12 months to obtain your copyright. So it's like pretty much the fastest, cheapest. Are you hearing this? Right? So when you're figuring out, and maybe you're new, or maybe you're not even a new business owner. I mean, every business has their budget, but it is a great way to protect certain types of works. And that's what we call them, works. Right? And then the duration is really interesting. So live long, okay? Live long, because it is 70 years. The duration of your copyright is 70 years after you die. Right? And if it's a work made for hire, meaning, like, say your work made for hire, that's like if where the company is when the company is the author, okay? Because the employee is creating something under the direction of, these are usually like W-2, like imagine a university setting. In a university setting, it's quite common on the patent side too, where you have, well, yeah, I mean, if you're contributing to something, and it's a work made for hire, you're an employee, and it's the company that becomes the author on the application, not you. Whereas even in patent, you would be an inventor, but then you would assign the rights to the university, just so you can kind of get the differences. But but yeah, then it's 120 years. Okay. So different, right? Like, you have to really think, like, when I'm identifying, that's the first thing, like, even in our identify, protect for life, right? That's our logo, that's our tagline and we have that trademark registration for it. So it's first, look at what you have. Is this a patent? Or is this a trademark? Or is this a copyright? Or could this be in two different buckets? Okay. I want to just run through trade secret, and then don't worry, we can keep talking, because trade secret is pretty quick. You got to keep it a secret. That's the biggest thing. Okay, you have to keep it a secret. But what are the kinds of things that you want to keep secret? Like think in your own business, right? Think in your own business, what would you want to keep secret? Like customer lists, suppliers, stuff like that, right? I mean, like Coca-Cola's formula, of course, is probably one of the most well-known trade secrets. And how are you keeping the secret, right? How are you actually keeping a secret? Because if you're not keeping a secret, like if all of your employees can like just kind of log into their computers and be like, oh, okay, trade secret folder, access to anybody, right? You're not going to be able to call it a trade secret. Now, what's nice about a trade secret is you don't have to pay the government. You don't get a certificate. You basically say, I declare it. But you have to be protecting it as a secret, right? And it has to be something that one would consider a secret. All right, so here's the rights. All right, you see it right there on your screen. The legal ability to create, maintain, own, and protect trade secrets primarily resides in agreements and policies, which, if properly drafted, protect from misappropriation. But guess what? Like misappropriation happens. We had a case, I mean, real life case here at the Daily Center. It's not a federal claim. It was a state claim. Trade secrets is a state claim, not like many patent and trademark and copyright cases, which are federal claims. So it was right here at the Daily Center. And, restaurant hired a relative and kind of like stole recipe. I mean, our theory of the case was she got caught with her hands in the dough, Your Honor. I mean, she took everything from the computer, everything, because she was an employee that was part of the secret. So when that happens, you win, and we won. Okay. It's got to be someone who, but if it's not a trusted individual, then, and you didn't take parameters to protect it, then you have a problem with that case. I mean, that would be a really tough one to win. So no formal filings, meaning no government fees, which is pretty amazing, and no time limit at all. It's not measured against anyone dying. It's not measured against use, right? Well, I mean, you got to keep it a secret. So from that standpoint, I guess, but it's not that you're using it necessarily. You got to keep it a secret. So it's really not based on use. So IP best practices. Okay. And do we want to, okay. When we're talking, remember I was talking about checklist, first identify, right? You've identified, you've gone through your website or your anticipated website, and you've gone through your marketing materials, however you are telling the world about how amazing and how life-changing or making your life easier, what you do and sell will be for your customers. Then once you've done that, you need to then identify, you've done. Now protect. Okay? So you've identified existing and potential IP assets. Done. Right? Then you secure ownership of assets. You maximize opportunities. That obviously is a wide array of things. You minimize your risk. That's like doing your searches, making sure that you don't choose something that is so close to somebody else's. So there's, like offense versus defense, okay, in intellectual property, in the selection of your trademark, for example, and management and maintenance, right? You got to docket this. So we have a very, obviously our docket is tailored towards, the patent annuities. That's, even after your patent is issued, you need to still pay these annuities. You're not done. You're not done. Same with trademarks. And how are you, say you've hit that 10-year, you've hit the 10-year mark, and you have successfully attached a proper specimen proving that you're using, and then you don't have another renewal for 10 years. How are you using the mark within that 10-year period? Because at that 20-year mark, 10 years later, we're going to be contacting, hey, send us, we need to know your current use. And you'd be like, oh no, we made a change, right? So stay in touch with your IP lawyer. Stay in touch with them. Okay. So identify your IP, right? We keep going back to that because it's that important. Okay. If you don't identify it, right, you never, that item that's missed never gets to step 2. Okay. So there's a whole, see your ideas, that's identifying your IP, but it's not protectable IP, right? Because we talked about it's not expressed in any way, but it is in your business plans, right? Your inventions, all the things. All the things. Okay. And now secure ownership. Identify, protect. Identify, done. Now we need to protect it. So for all the questions that we discussed already about doing the searches, what trademark do I select? Same with patents, right? Did I do the research? Did I file my non-provisional? Did I file my non-provisional? You have to file that within a year of your provisional. It can be early, you can be a month later, but it can't be longer than 1 year. There's so many deadlines in this stuff, and they're unforgiving. They're unforgiving. If it's passed, it's like, okay, public domain. So it's really important that you talk to someone that you know, like, and trust. Okay. So okay, so you've identified and now you're securing ownership, but what if you have someone else working, like maybe, independent contractor, let's not forget that is, or maybe you're fractional, maybe you're like fractional CEO, you need to have, licensing in place, who can use your, intellectual property, right? And then what if you want to transfer it for maybe financial reasons or succession planning, or there could be lots of reasons why you want to transfer your IP rights, or someone if you've got like multiple like arms of your business and you want to sell off one arm of your business, right? And you may have a different brand for that business. And you can sell off the whole thing to somebody else. You got to know who owns what and who has the right to do what with the intellectual property. All right. And confidentiality is a common term in these types of agreements. It doesn't need to be published to the world. Confidentiality only goes so far. Obviously, if you're in some kind of litigation, you need to, produce. That's what we call it when you produce documents in a litigation, meaning you've got to turn certain documents over to the other side, or if they've been subpoenaed. There's all kinds of, we do a lot of litigation at my firm as well as the application side, which has a fancy name. It's called prosecution, if you've ever heard of it, when we're talking about filing filing an application and monitoring and back and forth with the examiner through issuance, and that's all called prosecution. That's the fancy name for it. Okay. Actually, I want to go back to this bullet here. Employees, like employment contracts. So for those that have employees, have you looked at your employment contract to see how your intellectual property is handled. There should be an IP provision. Even if you had an employment lawyer put it together, take a look. Take a look and see if how your IP is handled, right? Because when there's termination of a employee and they might have a covenant not to compete, I don't, they could have that. And how is the IP handled? There's so many things, that need to be included in that employment contract. And we partner with employment lawyers because I'm not going to pretend I know all the nuances of employment law. IP is my thing, but I do co-counsel with other lawyers that know things better than I do, which would be the employment. But I do say take a look at it because it's something to look at for certainly IP and likely other things. So maximizing now we want to maximize. Okay, we've identified. Okay, we want to protect. We put ourselves in the best position possible. And one of the top things is register your intellectual property. Okay, unless it's a trademark. I'm sorry, strike that. Unless it's a trade secret. Okay, you want to register your IP. Marking. What's marking? So we touched on this a little bit earlier, which is what is your notice to the public that you consider your trademark or copyright or patent yours, right? It's those little symbols. And I was impressed to see someone was using the SM. So if your business is more service oriented, you can use the SM. If you're more selling products, then use TM. And, honestly, it's okay either way. Maybe you're 50-50 split, flip a coin, doesn't matter, right? Because once you actually have a federally registered trademark, everything changes to an R in a circle, either way, R in a circle. And then the C in a circle is for copyright. So you'll see, look at this PowerPoint right now. See, I have a copyright symbol with the year it was published and my firm name because my firm owns it. Okay. You can throw in an all rights reserved if you want. You don't have to. Okay. But if you don't have this on your website, this is like the cheapest, easiest thing you can do is have your tech person, or if that's you, because I know some of us wear like many, many hats, throw that down there for the year. So you need to put the C in a circle, the year in which you created it, whatever it is, whether it's your website, PowerPoint, whatever it is. Your someone had like manuals, like teaching manuals. I saw that in the questions. All of that should certainly have a copyright notice at a minimum. Okay, this is not even if you file. I mean, I think you should. Your manuals, your software code, all of that. I think copyright is a great way to go for that. Okay. And if you're selling things, I mean, people really aren't using discs anymore, but it used to be that you would see the copyright symbol on that as well. Okay. So, we tend to think as exploitation as a negative thing. Well, we own it when it comes to IP. Okay. You examine exploitation opportunities because exploitation, all that means is, yes, I'm using them to the maximum I can, my XYZ IP. All right. So whether it's licensing, okay, obviously just selling direct, right? Using your IP to attract investors. I mean, say you have some, the next disrupting technology, okay? The next greatest thing, then you're going to want to at least say you're patent pending or you filed your copyrights and that sort of thing to attract investors to come talk to you. Have you ever seen Shark Tank? They'll ask a lot. You may have not noticed, but they'll ask like what, like kind of what have you done as a patent pending, that kind of thing. So, and then of course they want shares of things. And if you haven't done like basic searching and stuff, you're creating too many unknowns for the maximum offer that you can get, right? So if you have things in place, then you're more likely to attract more attention, money, offers, that sort of thing. So when we say police intellectual property, because that's another way to maximize opportunities, it also means keeping people out of your market share. So imagine you have, say, like 20% of business in your market. Okay, just imagine someone else comes onto the scene. People have other market shares, and someone chooses a name that's close to yours. And then they're starting to chip away. All of a sudden, you're seeing you have 18% of your market share. So you're losing money. So, one way to maximize your share is to keep people out of your share. I mean, it's great to grow your share, but it's also important to keep people out. And one thing is policing. So, what does that mean to police? It could be done by you. It could just be like, okay, I'm gonna once a month, I put a tickler in my calendar to remind myself that I'm going to go online. Yep, I'm gonna Google my own company name. I'm gonna, use multiple platforms and see, am I seeing something that's coming up like me? Should I bring this to the attention of my lawyer? Maybe. Absolutely, maybe. We do a lot of enforcement. We do a lot of takedowns. You can take down, you don't have to necessarily, a lot of times people think litigation. Oh my gosh, that's so expensive. There are alternatives than just filing a lawsuit against someone. It usually does start with notice though. I mean, you send a cease and desist letter is common, right? Or you can contact them first yourself. So we have clients who do an array of things, but ultimately we do, I mean, part of our practice is absolutely taking down offending, say, infringing use of trademarks and copyrights. Okay. So that's the litigation. So, I mean, because, litigation doesn't necessarily have to mean a lawsuit. That can be very expensive. By the time you get to the merits, you've probably sunken in. I mean, truly, honestly, I wouldn't be surprised. 6 digits. I wouldn't be surprised because it is costly in our system. So there are these much less expensive ways to get people to stop. Okay, and the more you are online and checking, the more you minimize losing market share. You want to be no, I mean, if you don't enforce your rights, there's a defense called acquiescence, and it is exactly what it sounds like. You can sit on your rights. A lot of it's like, oh, but you let, I mean, it's a real defense. Well, you let, say I'm the defendant and I'm talking to the plaintiff and I'm saying, you let, A, B, C, D, E, F, and then now I'm G, and you're going to say, I have to stop. That's not fair. And the court will be like, you know what? You're right. That's not fair. Seriously. So you have to identify, protect for life, right? You cannot just sit on your rights. You need to actually be active and checking to see if people are infringing. All right. And of course, you don't want to disclose confidential information to people who shouldn't have it. And that's where these internal policies and practices are really important, in particular with trade secrets. But how even employees use, again, we're going back to employee handbooks, employee contracts. They're really important. And of course, docketing your dates, because like you've learned, just because you get the piece of paper, which now is no longer paper, once you get that email, I don't know, it doesn't seem as exciting, but it is still wonderful to get the acknowledgement of that electronic copy of your certificate of registration for whatever it is, that you're not done. And then, of course, clearance and just awareness. Just, be aware of what else is around. Because people are creating all the time. They are creating all the time. It's pretty remarkable. And people are filing from outside the United States too. Don't forget, like, people can file from anywhere in the world, as they say, Timbuktu. They can be filing applications in the US because they are planning, they're already selling their products in the US, or they're planning on it. Okay. So this is kind of, things that we have talked about in part, is that you want to maintain, police, enforce your rights, right? You want to do that. You want to continuously be aware, have I done everything I need to be doing? Should I be filing more with the USPTO, for example, United States Patent and Trademark Office, because I am refreshing my brand? Like, are we paying attention? Are you, have you talked to your IP lawyer lately? Okay, it's kind of like that, and we do encourage our clients. We don't always know, so please reach out and let us know so that we can get ahead of it, and put you in the best place possible, so that you can exploit to the best possible way. Okay. And so that it is true, like what they, if you have a great foundation and a great process, you will probably avoid less hassle, stress, avoiding spending more time and money, if you get ahead of things. Okay, so that concludes just my slides. I do want to get back to certain questions. I just want to make sure I could get through, just in case it answered some of those questions as well. So yes, podcasts do fall into intellectual property, absolutely. So like the podcast itself would be copyright. I mean, if we were in person, because I do teach certain classes in person, and we can, it's a little bit easier, but if we still have some time, we can do some of these things. But for this one, I'll just go ahead and say, yes, podcast. But what are you calling the podcast, right? So the podcast name would be the trademark, and then the podcast itself would be the copyright. But you do mention titles, so it kind of depends on what you mean by titles. So the title of a podcast, I would assume you have more than one, if it's a podcast. And so yes, it would be protectable. But when you're talking about movies, books, those sort of things, you can't protect a title unless it's a series. Okay? You cannot protect a title unless it's a series. So think of horror movies as like a great example, right? Because you have like Halloween 1 through, I don't know, whatever they're at now, 102, I don't know. But when people are coming out with the sequels, do you notice that the titles are the same or very similar? It might be like the same first part, and then they'll be like New Dawn or whatever it is. Okay, that's why. Same with books. Like you can look up. Are you familiar with the For Dummies series? For Dummies. So the way they're registered, I've seen their registration, their trademark registration is it's ... for dummies. ... for dummies. So that is, a way to do it. Is think of your series. What's it going to be? I host a podcast that they're the trademark for the title of that, and different intellectual property topics. So yeah, that also. So think about that. And then let's see. I'm going to scroll up a little bit because I think I missed quite a few. Yes, Coca-Cola formula is a trade secret. I don't know, I honestly don't know if this is urban legend anymore, but there was someone who left, a disgruntled employee, left Coca-Cola, went to Pepsi. I think it's real. I mean, trust and verify, okay? And they wouldn't even talk to her. Can you imagine that litigation? Nope. Garrett cheese. Okay. I didn't know. That's Carrots popcorn, I presume, right? Yeah, their cheese formula. Yeah. So definitely there are. But I do know, yes, yes, absolutely. They do exist. There are other famous trade secrets that exist. Let's see, I'm just kind of scrolling. I want to make sure I didn't miss anything. Okay, so I do want to go back to, so you've got your company name, which is not a trademark, that's done at the Secretary of State, and then you've got your photo service as one of your services, so whatever you're calling it. So for example, let me just talk about one more tidbit on keeping straight between your company name and your trademark, okay? I think part of the reason why it gets confusing is especially for those people that are using a trademark that's subsumed in their business name. Okay. My business name, Advítam IP LLC. My trademark, certificate on the wall, Advítam IP. Okay. That is my trademark. So you might have, let's take an example, like Philip Morris, right? You've heard of that company, Philip Morris, well-known company. That's the company name, brand, Marlboro. Many brands, many brands. Okay. But I'm just saying it's not always that way, but it can be. But it doesn't mean that your business name is your trademark. Two separate offices that do not speak to each other. And then do I trademark the photo service too? Well, what are you calling the photo service? I mean, this is rhetorical. I mean, because other people are probably in a similar situation on this call. Think about the different branches of your business. Yeah, you can have multiple trademarks. Absolutely. You can have, oh, well, I'm calling this XYZ brand name and that ABC brand name. Absolutely. Absolutely. I mean, when you think of trademarks, walk through the grocery store. If you really want to understand trademarks, go to like the tomato sauce, for an example. Okay. There are so many different brands, all for tomato sauce. Okay. And then the photos themselves in this particular example, but the actual photos is copyright. It's probably now, right? Now, it's that. Let's see. Yes, I'm fine with the as far as is it possible to have a copy of this information? Absolutely. I told the organization they can distribute it if people find it helpful. That would be great. I think it's a great source of basic information. I don't think it's the end all be all. You have heard a lot of my voice in the last hour and a half or so. That was not just the bullet points. So definitely reach out to an IP professional for additional guidance. But I do think this is a very good basic tool to understand the differences between different areas of intellectual property, which is just the umbrella. I created an intranet from the ground up at my previous employer. Does my work belong to their, okay, so does it belong to them? Is it their IP? It depends. Likely it's theirs. Work made for hire. That's my initial gut reaction, but I don't know all the facts. I don't know what kind of contract it was. I don't know, if you're an independent contractor, a lot of those things. I mean, if that's what they hired you to do, I would say it's theirs. But I can't give you a yes or no without more information. But I would imagine if that's what they hired you to do, you did the work within the scope of your employment with them or engagement with them if you're an IC, independent contractor. But it may be more nuanced. It might be that there's more facts to know to make that determination. Okay. Let's see. I have a logo. Do I need a trademark and copyright? Not necessarily. I would say logos typically are trademark. It doesn't mean that the art itself, you probably could do, it's possible you could do both if it's a logo. I would say start with the trademark. And if we wanted to do, or sometimes people run into complications at the office for whatever reason, it could be a fallback, or you could do both. It doesn't hurt you to do both. Okay. Let's see. I have an art business and I'm coming out with a new series of 5 to 10 paintings with a specific title for the series. Do I copyright the images and trademark the title of the series? Gold star. You get it? You get it? You get it? Excellent. Let's say if I use similar technology from the internet I developed in the future, what should I do? I'm not sure I understand that question. If you use similar to who from the internet, so if you develop the internet and you want to use similar technology, you want to develop, like build on top of it, then another copyright. So as you continue, so same with websites, like you can, you're constantly building, if I understood the question right, you're constantly building, changing. You can get a copyright for the look and feel of a website because you're going to be changing the language in and out. You can also, of course, include the language and then you can continue to file. I mean, people revamp websites and it's really useful in enforcement. That's like when we're talking about like policing and enforcement, is to have updated copyright. It doesn't hurt you to have more IP to like attach, certificates and whatnot. Or they all have numbers, unique numbers to like insert into the cease and desist letter. It's all helpful. So when we talk about maximizing opportunities and things like that, that could be a way to do it. Okay. Let's see. We hit the podcast question. And then on the use of watermarks on documents in the form of company logos. Um, it is a form of, let's see, watermarks. Watermarks has to do with authenticity. This is a real, this is a real authentic original of whatever it is. It's not necessarily intellectual property. I don't know what if the watermark, a lot of times watermarks are just kind of like an, the inner on like it could be a seal within or it can be just in the stationery. You know how you can have like certain, like the, proprietary can be like written, like very faintly when you hold it to the light, you can see that it says proprietary information. A lot of that has to do with just that this is an original document, not necessarily that, or for counterfeit goods. So a lot of watermarks like holograms and things like that are put on legitimate products so that it's harder to counterfeit. So if you've got goods coming in to the United States or going elsewhere, and it's real popular, like a toy, for example, and people have like watermarks or various holograms and that kind of thing. So customs can like check to make sure it's legit product. The only issue, I just will mention this, is that counterfeits, as we get smarter, so do counterfeiters. So it's good to kind of keep changing and whatnot. But from a standpoint of the watermark itself, being a form of marking, it is for authenticity. But if it's like on like a patent, you like on a patented product or an invention that maybe you should think about patenting, that's not marking. Marking is for patents is it actually says patent pending. It's that simple. It's just patent pending. So it kind of depends on, I need a little more information, but I hope that was enough that I covered it. Thank you. And then yeah. So is there a question on the unos and duos? Is the question like how'd they do that and get away with it? I don't know enough details to tell you specifically if it was okay or not. But you're right. I mean, it's like which one should we go to? Yeah. So I don't know the answer without a little bit of recon. Can you tell us more about the in-person classes you do? Okay. So it's more, okay. There was an organization called the Young Entrepreneurs Academy, and I teach their IP course every year. It's an after-school program. It's great if you have kids between 12 and 18. I'm not teaching at a university at the moment. I was teaching at Columbia, adjunct on this subject matter to film students in particular. But no, other than that, I'm not teaching a class that you can sign up for. But feel free to contact me if by email is easiest for you, and let me know if you have additional questions. I'm happy to answer what I can. Don't forget to click the link for your certificate. And yes, copyrights would photos and scripts like manuscripts, if that's what you intended, those definitely fall under copyright. Okay. Yes, if you hire someone, the question is, if I hire someone to do the work, do I need to send them an agreement? Oh, I highly recommend that. Highly, okay? And it should include terms that relate to all the employment related type of terms and termination and things like that, and what your title is, what are you considered, like a kind of a, independent contractor versus W-2, employee. It should definitely include that. I don't know. So because I'm not an employment lawyer, I don't know what a FIVERR is. I don't know. I don't know what that is, but IP should definitely be included. Okay, because last thing you need is, it's already a headache losing employee. I know, and so like then and they're off with your IP and getting them stopped. I mean, it's much easier to say like, here on provision XYZ says this. Much easier. Where can I recommend? Where can I recommend publications that enter public domain? Honestly, you could probably just like Google that there's probably libraries, like online libraries that have that sort of thing. And same with IP for filmmakers. There's so much out there that and I graduated a long time ago, so I don't even know what if there's like the school book. I still have, honestly, one of my favorite books is called it's called Nutshell, IP in a Nutshell. I still I haven't looked at it in a while, to be honest, but when I was beginning in this practice, I kept going. That was like my Bible, IP in a nutshell. And it was like a teal green book, and it was paperback, and it wasn't that big. It literally was like this size, and it was a great book, IP in a nutshell. I would recommend that one, but it's not specific to any particular area. So, but I was so for the person who's looking for IP for filmmakers. So I taught at Columbia locally here. It was just adjunct. I wasn't even like official. It was volunteer. Because one of my friends from law school was teaching there, and so I every year for years I did a presentation on IP related to filmmakers. So perhaps they have something, because it was actually, she brought me in every year. I was like for 5 consecutive years or something like that. Let's see, who publishes a list of publications that, oh, okay. So check online for that. I don't know of a specific one. Oh, okay. Thank you. I appreciate you for telling me what Fiverr is. I hate to pronounce things wrong, but it's a freelance website that's from abroad. Okay. So I'm not familiar with it, but if it's a website, check it out if you think it might help you. Yeah, so I mean, so the podcast is that I do is called it's called um the Women's IP World. That's what it's called, the Women's IP World. I'll just cut it there. Women's IP World. So what I do is I interview women lawyers who practice in the IP space from around the world to provide a spotlight to their specialty. So that is free and available if that's something someone is interested in learning about. We're just starting our 5th season. So that's what that podcast is about. But if you want just kind of general, I would just kind of search online and see if there is, I would imagine. I've been on other people's podcasts talking about IP. So I know that there's an employment. I've been on there's an employment one that I've been on, or probably more than one, but I've been on that talking about IP. So it's definitely out there. There's so much information out there. Let's see. Oh, wonderful. graduate from child graduate. That's a wonderful, who knows, depending on when that was, I may have taught the IP for his film class. And I don't see any more questions. I don't think. Did I catch them all?
I think you did. You did a great job.
Okay. Oh, and it's 11:03. I'm sorry.
Yeah,
I didn't mean
no,
to
you're
hold.
good.
I'm
No,
very sorry about
absolutely
that. I try to
great.
be mindful of the time, but we're just having so much fun here.
No, so
So
much great information. We're getting a ton of thank yous, great information. Everyone appreciates your taking the time out, especially going through all the questions. That was awesome. So just want to say thank you to Michele. Again, thank you so much. Such great information and appreciate your time. Thank you everyone for attending. Hope everyone has a cool and fun weekend. And I also hear the air show flying above us right now. But thank you everyone. Have a great weekend.
thank you. Bye-bye.